Hey everyone, welcome back to the channel. Today we're breaking down one of the latest developments in Florida gun law and Second Amendment rights. My name is Tonmiel Rodriguez. I am a Florida board-certified criminal trial lawyer. Today's story comes straight out of Broward County, and it's a big one. A circuit court judge has ruled that Florida Statute 790.01, which criminalizes concealed carry for people under 21, is unconstitutional, at least as applied to this 19-year-old defendant. This decision doesn't change the law statewide yet, but it's an important signal of where Florida gun jurisprudence is heading. Let's dig into what happened, what the judge said, and what it means for you. The case began back on March 21st, 2025 in Plantation, Florida. According to the Broward County Sheriff's Office booking report and the complaint affidavit, Officer O. Welch responded to a call about a disabled white 2025 Chevy Corvette on the 4100 block of West Broward Boulevard. When the officer approached, he met 19-year-old Joel Andrew Walks, who was the sole occupant of the car. Walks told the officer he was waiting for his uncle to arrive with a tow truck because his car had broken down. While talking with him, the officer noticed a bulge in Walks' waistband, and he got a little suspicious, and he asked Walks about it, and Walks admitted that he was carrying a loaded Glock 17 handgun tucked in his waistband. He was cooperative and he turned the gun over right away. Under Florida law, anyone under 21 years of age is prohibited from carrying a concealed firearm, even though they can legally own one through a gift or inheritance. So despite having no other alleged criminal conduct or record, Walks was arrested and booked for carrying a concealed firearm under Florida Statute 790.013, which is a third-degree felony punishable by up to 5 years in Florida State Prison. Fast forward to the summer of 2025. Walks' defense attorney filed a motion to dismiss the charge, arguing that Florida's concealed carry age restriction, which limits concealed carry to 21 and older, violates the Second Amendment. Their argument was simple. 18 to 20-year-olds are legal adults under both state and federal law. They can vote, they can serve in the military, sign contracts, and be tried, prosecuted as adults. Denying them the right to carry a firearm for self-defense strips away a fundamental constitutional right. The defense relied heavily on recent Supreme Court cases like District of Columbia versus Heller, McDonald versus Chicago, and New York State Rifle and Pistol Association versus Bruen, all of which emphasized that the Second Amendment protects an individual right to keep and bear arms, not just one limited to militia service. On October 24, 2025, Judge Frank Leedy, I'm not sure if that's how you pronounce it, it's spelled L-E-D-E-E, of Florida's 17th Judicial Circuit, agreed with the defense and dismissed the charge. Here's what the judge found. Walks was a law-abiding 19-year-old adult who legally possessed his firearm. The conduct, carrying a firearm for self-defense, falls squarely within the text of the Second Amendment. Under the Bruen decision, the state bears the burden of proving that the restriction prohibiting 18 to 20-year-olds from concealed carrying aligns with historical tradition. The state argued that historically, many 19th century laws restricted gun sales to minors under 21. But the judge rejected that, pointing out that the founding era, not the 1800s, defines a constitutional standard. Again, the founding era, not the 1800s, defines a constitutional standard. And in that founding era, men as young as 18 were required by the Militia Act of 1792 to keep and bear arms. The judge concluded that Florida's ban on concealed carry for 18 to 20-year-olds is inconsistent with the nation's historical tradition of firearm regulation and therefore unconstitutional. Judge Leedy also referenced the recent case of McDaniels versus State, where Florida's open carry ban was struck down under similar reasoning, signaling a growing judicial skepticism about Florida's restrictive gun laws. Now, before anyone under 21 runs out and starts concealed carrying, slow it down. This decision is not binding statewide. It's a circuit court ruling, which means it only directly affects this case, State versus Joel Walks, and has no precedential or binding force beyond the 17th Circuit in Broward County. The state attorney's office could appeal the ruling to the 4th District Court of Appeal until a higher court weighs in. Florida Statute 790.013 remains on the books and is enforceable in the state. However, this ruling is part of an emerging judicial trend in Florida where courts are beginning to apply the Second Amendment's text, history and traditions rigorously. And when they do so, many modern firearm restrictions, especially those based on age and public carry, are being viewed at odds with that historical tradition. So in short, a 19-year-old was arrested for carrying a concealed firearm. A Broward County judge said that Florida's law prohibiting him from concealed carrying a firearm violates the Second Amendment. The charge was dismissed. And while it's not binding statewide, it adds fuel to an ongoing debate and might just be a preview of what a Florida appellate court may rule in the near future. Bottom line, it's not looking good for Florida's concealed carry restrictions for 18 to 21-year-olds. If you found this breakdown helpful, please like, subscribe, and share it with a friend who needs to know. My name is Tonmiel Rodriguez. I'm a Florida board certified criminal trial lawyer, and in this channel, I am to keep you informed so you can avoid legal trouble. Thanks for watching. I'll see you in the next one.